Good evening, ladies, and today is August 14th, Friday. I am getting ready to walk out the door, but before I left, I wanted to do this video. I've been thinking about what I was going to do all week, and I wanted to do this one on DWIs. This one, without further ado, is the 5 don'ts of getting a DWI. Alrighty? The first don't is don't drink and drive. Don't get a DWI. If you don't get a DWI, there's nothing to worry about. But if you do, the second don't is don't talk, don't answer questions, don't get tricked into answering questions. The officers are going to ask you things like, "Oh, hey, how are you doing tonight? I smell alcohol on you. Do you got any bombs in the car? Do you mind if I search?" They're trying to lure you into answering their questions, to being friendly with them, so that you can trust them. Don't answer questions. Do the basics. Hand them their card. Give them your name, and then that's it. What they're trying to do is they're building a case from the first time they stop you. If they've stopped you and it's late at night and they smell alcohol or you've been drinking, they're going to arrest you. That is a fact. Nothing you say and do at that point can help you at all. They're going to arrest you. Do not answer any questions. They're going to be taking notes on the fact of whether or not you answered the questions right, whether or not you were paying attention, slurred speech, whether or not you were able to do the right thing they asked for. They're also going to do divided attention. They're trained to do this. They'll ask you to do one thing. While you're doing that, they'll ask you to do something else to confuse you, and they'll also ask you questions about where you're coming from tonight. What are you doing? Where you live, where do you work? The purpose of that is to get your attention divided so they can start seeing how well you do, because alcohol inebriates you and makes you unable to focus your attention on more than one thing. So don't answer questions. Don't do any of that. The third don't do roadside tests. There's nothing there that can help you. You can't ace a roadside test. If you do them all well, I could use that in court to say, hey, he did those tests well, but you know what? That rarely ever happens. If they're asking you to do roadside tests, they're asking you to testify, to build a case against yourself so that you perform poorly and that they can prove, hey, he failed this, he did this, he had all the 6 Qs of the HGN, the horizontal gaze and stagnus. Nothing you do at this point is going to help you, so don't do the test. Plus, the only test that you have to do at this point at all and not face any repercussions is to blow at the sheriff's department or the police station. That's the only test you are required to do. And if you don't do that, they take your license for a year. You don't have to do any test. So nothing you do on the roadside, from the PBT, the portable breath test, you don't have to do that. You don't have to do the walk and turn. You don't have to do the one leg stand. You don't have to do the finger and nose. You're not going to pass them, especially if you've been drinking. So back to number 1, don't drink. But if you are going to drink and drive, don't do the tests. The fourth thing is, if you were in an accident, don't admit to driving. One of the hardest cases for the state to win in a DWI case, and the easiest ones for defense attorneys to win, are accident cases. You've been in an accident. Well, what are the elements of proving someone was drinking while intoxicated? Driving while intoxicated. They were driving while intoxicated. 3 things, basically. If they didn't see you driving, it's going to be hard for them to prove to the court that you were driving while intoxicated. Without that, all they can prove is that at some point you may have been driving, and when they saw you, you were intoxicated. But if you say, oh yes, I was driving, I had a few drinks earlier, and they got a form, all these forms filled out, they are already prepared and made by the Department of Health and Human Services, the Department of Public Safety. It's all made for them so that they don't miss a beat. They know exactly which questions to ask you to build a case against you. They're going to ask you, when was your last drink? How many drinks do you have? How drunk do you think you are? They're going to ask you that, and you're going to say, oh, I'm not that drunk. I only had a few drinks. When did you last drink? Well, if you last drank 2 hours ago and you said that you were the one driving, they're going to say, well, he was driving while intoxicated. So don't admit to driving if you were in an accident. Be polite, be cooperative, don't drink and drive, but don't admit to driving. The last thing is, don't wait. If you get charged with a DWI, you're going to get out usually that night or early the next morning, but don't wait to contact an attorney. If you blew less than a .15, you will be eligible. Just by getting the charge of drinking while intoxicated, you're going to lose your license for an automatic period of time. If you blew less than a .15, it's 30 days. If you blew more than a .15, it's 45 days. But If you blew less than a .15, you can get a limited driving privilege for days 11 through 30 for the under a .15 if you do a substance abuse assessment and pay a $100 fee to the clerk's office. And the judge signs it. You have to be eligible, obviously. And then if you blew more than a .15 or more, you can get that limited privilege after 30 days instead of having to wait the whole 45-day period if you do the same thing, a substance abuse assessment, and get the court to sign it. If you hire me, you can, and also my fee for pleading DWIs is $1,800. It's a flat rate of $1,800 that includes us going to court and pleading. You usually get that done rather quickly. And if you want to fight it, it's $3,200. We work out payment plans. Usually people can't afford that right off the bat, but we can do a payment plan with as little as $500 down, and I get in the case. Always, for criminal cases, I always do the consults free. I tell you everything that you need to do. And if you hire me, I include in my fee the license privilege, doing the paperwork. Obviously, you have to pay the court costs, but I do the paperwork for pretrial, and if you are convicted, I do the paperwork for your post-conviction driving privilege. And if you do get convicted of driving while intoxicated for over a .15 or higher, you will have to get an intoxilizer in your vehicle and have to wait 45 days at that point. But do the consult, come to my office, call my office, shoot me an email, text me. We will set a time for us to talk and discuss your case, because each case is unique. What I will do is I'll be blunt with you. I'll say, look, I think that in your situation, they got you dead to rights. It's your first DWI. We can go ahead and get this plea knocked out. You're likely looking at unsupervised probation. You're going to have to pay some fines. Your insurance is going to go up, but you don't have to keep coming to court and waiting. Or on the other hand, if it's a good case, if I like the case, hey, no one saw you driving, we can fight this. I think we can fight it. We can do some maneuvering. I can file some pretrial motions, maybe suppress the stop, try some things, and then $3,200. We fight. It will take a while. Usually DWIs here in this district in Franklin County, they take around, on average, at least a year to fight to get a court date, because we only have two dates a week to do it, and everything has to be lined up with the officers and their schedules, and they have lots of training to go to. Training so that they know how to arrest you and build a case against you. So, with that being said, call us, text us, email us. We are here for you, and we will fight for you. Thank you, and you have a great weekend.